you very much for the presentation and the organization of this Human Rights Day the second time. And I welcome all participants, those who know each other very well and those who we meet for the first time. To add something to these great achievements that we have heard, I have to say that last year the European Court of Human Rights was celebrating the 75th anniversary of the Convention, and there were a lot of events organized both in Strasbourg and in other places, from Warsaw to Hague to Budapest, etc. But the registrar of the court, who is the boss of the court, told me that there was only one event celebrating the 75th anniversary to which the court didn't contribute even with 1 cent, and this was the event in Budapest. So let's confer this gratitude from the court and from the registrars. And actually, like 7 or 8 judges from the court were present. It was so successful that when months ago the group of students from Central European Academy visited Strasbourg, I sent email to 7 or 8 judges thinking that at least 3 will be able to meet the students. All of them answered in 10 minutes. So this has underlined one of the judges there. That was the first time in the life of the court that 7 judges were making presentations during whole day only for students, so not at a conference, etc. So I think that this, and I hope that this cooperation will continue the next time with the presence of those other judges from the European Court of Human Rights. Just to say a word on me, I was judge from the European Court of Human Rights elected for Hungary since 2017. It means that my 9-year term will end in 2 weeks. But as there is no successor to substitute me, so probably I will stay at least 1 year more. So I'm experienced but still facing challenges. What is unpleasant, it's not unusual that judges continue their term. 4 judges are before me in seniority, in the sense that one of them is almost 4 years overdue. What is my problem? That in age I am the oldest from this month at the court, and this probably will not change. Okay, thank you. The title of my presentation was Challenges for the European Court of Human Rights, and those who know me would have heard some of my previous lectures, different events at the Central European Academy. They know that I cannot miss to start with some historical view on, and also very shortly, let me say that I was listing the challenges, by the way, endless challenges to the European Court of Human Rights. I think that the first historical challenge was the acceptance of an international court by that time 10 European days, because the idea of an international court, supranational organization, was present in European political and legal thinking from the Middle Ages. Just to mention a few names: Pierre Dubois, Sully, Abbé, Saint-Pierre, Kant, Coudenhove, Kalergi, and the Pan-European movement, League of Nations, etc. But all these initiatives remained unsuccessful. The first initiative was the adoption of the European Convention on Human Rights in 1950 in Rome, and the establishment of the European Commission of Human Rights and the European Court of Human Rights within the framework of the Council of Europe. So the breakthrough was the Council of Europe, and within that network the first international court that delivered its first judgment in 1960. And in the first period, the court had gradually made the founding members themselves and their courts, the legal systems of the member state, to accept an international court judging under an international convention and breaking the principle of supremacy and exclusivity of the domestic law. which derived from the sovereignty of those states. The democratic states concerned had a highly developed legal culture, considered their own law to be the most appropriate and rooted in their tradition. These legal systems were also very different from one each other, as in the case of the English, the Irish, French, Italian, German, or later on the Scandinavian legal systems and families. So we can imagine that the difficulties that the Strasbourg Court encountered in declaring a breach of the Convention by a measure taken by a member state or by a court judgment. But the court had gradually built up its authority. Also, historically looking back, we must not lose sight of the reasons for the historical development of European institutions, the Council of Europe, and also of the Court. It was to establish true democracy through individual freedom, political freedom, and the rule of law. Regardless of its initial economic framework, the real aim of the European integration was also to establish peace in Europe. So basically, the Council of Europe was a peace project. These goals, although they may be overshadowed by the successes and failures of recent decades, are still valid today. So this first challenge, namely the relationship between the court and the member state, is still alive today, and the implementation of the convention is a matter of the national courts, national judges, but nevertheless there are a lot of contradictions, problems raised, just to mention the subsidiarity, margin of appreciation doctrine, and so on, and maybe I will come back to this issue later on. The second historical challenge was the enlargement of the Council of Europe. In the 1990s, after the fall of the Soviet-type dictatorships in Central and in Eastern Europe, and the Council of Europe expanded to include these countries with no or small democratic or lay democratic traditions, or at least countries without democratic continuity for decades. So these states had to learn about the institutions of the rule of law, how they work, the protecting human rights mechanism, and so on and so on. But also at that time, the Council of Europe and Court and Convention opened up for individual applications, changed the system of the procedure, and diminished the role of the state in accepting a process against themselves, and so on. And what is usually said, it's like a commonplace, that the court became a victim of its own success, especially that year when it had 160,000 pending applications before it, which is impossible to solve. This resulted in a fundamental change in the life of the institution, the merger of the Commission and the Court of Justice, a permanent court sitting all the time and not just periodically, and everything was put in place in 1998. But the problems are still we have to face. Just to give an overall list of the challenge of present day or the challenges of the last decade, so to say, were the economic crisis, second, the terrorism and the measures taken against terrorism, then armed conflicts, then the frozen territories at the borders of the Council of Europe, or between, at that time, member states of the Council of Europe around Russia, then the migration problem, the technological revolution, including the digitalization, environmental problems, climate change, environmental litigations, then for a time the COVID pandemic, then attacks against the European Court of Human Rights within this the episode when Russia left the Council of Europe, then the rule of law problems, including the judicial independence issue, then finally the implementation of the judgments, which is a continuous problem for the Council of Europe, although I have read, let me quote the nice sentence, international law scholars consider the European Court of Human Rights to be the most effective international human rights court in the world, says an authority, not me. Then, of course, I will not address this list, just some of them, how to say, by rather subjective choice. Interestingly, last year, even this year, several articles having the same title, the challenges to Strasbourg, challenges for the European Court of Human Rights appeared, and they made differences between the internal and external challenges. Well, I will try to follow this scheme, but honestly speaking, these challenges are interwoven. But let's say that the internal challenge is, first of all, the caseload and the structure of the court. I'm speaking of this because, how to say, the external challenges are more clear and more visible from the outside, but what the court is doing inside, it's not really known, not really known. The statistics prove that despite the several procedures that the court introduced to deal with the extreme number of applications, still we have a backlog that is worrying. Ongoing challenges were settled by a lot of reforms, but nevertheless, still we have 32,000 applications allocated to judicial formations, which was a 10% increase from the previous year. And what was a real breakthrough on the other side, and the real success, that the cases pending before the chambers are only 9,300 compared to the almost 20,000 the previous year. And as we know that the court can deliver 3,000–4,000 judgments a year, that means that even the 9,000 judgments are not so, how to say, terrible than previously when we had more than 20,000 judgments. That means that the munition for 7–8 years coming. Let me speak of one of those measures that were introduced to deal with this incredible amount of individual applications. One measure was the so-called well-established case law. Well-established case law is from 2014, was the idea to speed up the processing of repetitive cases with a summary procedure, mostly in 3-member committees. Unfortunately, this has also its problems because a pilot judgment is delivered, then the other applications, repetitive applications, go to this well-established case law procedure, and honestly speaking, it's signed by judges. It's signed by judges, but I honestly say I never read them because it's impossible. It's generated by a computer, so no judge can explain why is. Then, of course, we can say that why was, for example, so long the procedure, and what are the money to be paid as just satisfaction. But as a matter of fact, I have the impression that this VEX procedure a little bit works like an ATM, an automatic teller machine, when the application arrives and then the court obliges the state to pay, and the applicant go to the ATM and get out the money. But what was the source? This pilot judgment procedure. Pilot judgment procedure is a procedure that is not institutionalized in the convention. It was invented by the court and later on institutionalized in the rules of the court. This is Rule 61, and in this sense is very similar to Rule 39, the interim measures, which also does not have any reference in the convention itself. So, huge number of cases pending before the court are repetitive cases, lengths of procedure, prison conditions, etc., which derive from a common dysfunction at the national level. The pilot judgment procedure was developed as a technique of identifying the structural problems underlying repetitive cases against many countries and imposing an obligation on states to address those problems. This was completely different from the original idea of the Convention and of the Court to deal strictly with individual applications and with individual injuries suffered by the applicants. Here, the Court turns into an identification of structural problems and obliging the states not just pay just compensation for the injuries caused to the applicants, but to change the legal system by legislation, etc., or a different level. So the Court receives several applications and selects one or more for priority treatment under the pilot procedure. In the pilot judgment, the Court's task is not only to decide whether a violation of the Convention occurred, but also to identify the systemic problem and to give the government clear indications of the type of remedial measures needed to resolve it. A key feature of the pilot procedure is the freezing of the related applications for a period of time on the condition that the government acts promptly to adopt the national measures required to satisfy the judgment. So the objectives of the pilot judgment procedure were to assist the European states that are party of the Convention in solving systemic and structural problems at national level. Secondly, offer a possibility of speedy redress to the individuals concerned, and to help the Court itself to manage the workload more efficiently by reducing the number of similar cases. The first case was the Broniowski versus Poland Grand Chamber judgment in 2004. That was where the structural problem was that after Poland, the eastern border had been redrawn in the aftermath of the Second World War, Poland undertook to compensate Polish citizens who had been repatriated and had to abandon their property beyond the Bug River and now in Ukrainian, Belarusian and Lithuanian territory. Following an application by a Polish national who complained that he had not received the compensatory property to which he was entitled, the Court found that the case disclosed the existence within the Polish legal order of a structural deficiency which denied a whole class of individuals, some 80,000 people, the peaceful enjoyment of their possessions. So this was the first one, and then the follow-up was that the similar applications were adjourned. Poland passed a new law in July 2005 providing for financial compensation for the properties abandoned beyond this river. The Court found that the new land and compensation scheme was effective, struck out in 2007 and 2008 more than 200 similar applications. This, for example, in Hungary and other countries, was applied to the length of proceeding. In Hungary, it was solved for the length of proceeding in civil procedures. After the pilot judgment, we delivered a decision suspending all the other applications, saying that it depends on the legislator, which the legislator solved the problem. Then regarding prison conditions, when I arrived to the court, there was 11,000 applications pending for Hungary. This was only in 2017, November, was the only month when Hungary had the biggest number of applications. Now we are in the 15th, 16th place. And this prison conditions issue was also solved by legislation, by the government as well, and then delivered another decision saying that we can now cancel and delete the other applications, and it was solved by a domestic compensation system for the prison conditions. We get rid of 8,000 applications. We had a separate room to store all these applications. Now Hungary has 500 applications. And to end the story, I picked another Polish case, the Valenza versus Poland, the Grand Chamber judgment from November 2023 that became final in February 2024, where I was not a member of, I was in section 1, which includes Poland, but I was not a member in these cases. For whatever reasons, I don't want to speculate on it, where they dealt with the judiciary and other problems in Poland. This Grand Chamber judgment indicated as the structural problem that the judicial reform in Poland initiated in 2017, and that the court held previously that a double violation of the right to fair hearing under Article 6 of the Convention and the malfunctioning of domestic legislation, then a defective procedure for judicial appointments involving the National Council of Judiciary, then thirdly, the resulting lack of independence on the part of the Chamber of Extraordinary Review of the Supreme Court, then fourth, the exclusive competence of the Chamber of Extraordinary Review and Public Affairs of the Supreme Court, and so on. And the measures required by the court was the appropriate legislative and other measures to secure the national system, the independent and impartial tribunal established by the law, the principle of legal certainty. And the first was adjourned by 12 months, the solution, but as we know, for different reasons, this issue has not been resolved due to the presidential vetoes, but also the international legal community raised several questions regarding the possibility of solving this problem, for example, with the dismissal of all judges of the Constitutional Court or all members of the National Judicial Council. So while it started in 2004 with a Polish case, this pilot judgment story, it's now a bit disturbed 20 years later by another Polish case. Anyway, what's going on still is the prioritization policy that every year all national divisions have to, with agreement with the judge, to indicate which are the priority cases. Then they introduced the notion of the so-called impact cases, because of course what have absolute priority are cases connected to Article 2 and 3, life and prohibition of torture, etc. But there were also a lot of other cases that were not under these two articles, and it took 5-6 years to proceed to process all these cases. So therefore then the national divisions pick for every year like 6, 8 or sometimes more impact cases. Not all countries, because last year, I was wondering at the statistics, there were only six cases against Germany, so they cannot pick 6 impact cases or 8 because we don't have cases and so on. So, but this is not the case in our countries. It's different. And so then this is, I think, one of the internal problems that need continuous answers. The second problem, at least for me, and I think that's my personal view, that the real threat to the court is the contradictions within the case law of this court that delivered from 1960 until 998, 800 judgments in almost 30 years, now delivers 3,000 judgments every year. The 5 chambers work like 5 different courts. I'm not saying what I know of the judgments of other sections, But I just quote a friend of mine, a previous judge, professor at Strasbourg University, and he was teaching human rights law. And he followed continuously the important judgments delivered by the court. Said, since he's judge here, he has no idea about what the other 4 sections are doing. There's no time for that, just dealing with own cases and so on. And now we had the case was not interesting in the Grand Chamber. It's Tsava versus Georgia. It was a demonstration issue. But we had to face a problem because the court deliver under Article 2 and Article 3 delivered a practice which is, I think, unknown other international courts to approach the right to life and the prohibition of torture, etc. issues either on the substance or on the procedural limb, as we say. And sometimes they say that this is a procedural violation because, for example, a situation was not investigated thoroughly by the authorities, or we say that this was a substantial violation of right to life, etc. And then, in this case, the Grand Chamber, I was a member of this, so I know, the Grand Chamber wanted to clarify what is the relation between the so-called procedural limb and the substantial limb of these 2 basic articles. From my experience, I thought that our case law is diverging either to deal first with the procedural limb, and if the procedural limb we find a violation or negligence, etc., we don't continue with the substantive limb because it's enough. Or we don't find anything on the procedural, and then we go to the substantial limb, and maybe we find something or not, etc. No, I was naive. There, the research report on this issue detected at least five different solutions. And there is no coherence or logic when do we apply one solution and when the other one. So basically what I draw from this research report was that finding of a procedural violation could directly impact the substantive analysis. Secondly, maybe no impact on the substantive complaint because the court can rely on the evidence before it to find a substantive violation without the need to refer to the procedural limb. Thirdly, there may be no impact where the court finds a violation of procedural limb, but it's unable to establish a violation of the substantive limb before it. And what is confusing, that the impact of the finding of a violation under the procedural or the substantive limb depends on the category of case and whether certain presumptions can be established. And I'm afraid that this is not really what we call legal certainty. And probably not by accident that neither the Inter-American Court of Human Rights nor the African Court distinguish between substantive and procedural limb. Turning to the more well-known external challenges, I would like to refer to the armed conflicts, the war in Ukraine and other issues and all the problems linked to Russia and these wars and frozen territories. And because, as I mentioned at the beginning, that the Council of Europe basically was a peace project. So I mean to deal with these interstate cases. I don't know how I did, but in my 9 years, I've never been involved in any interstate case. So I'm really an objective observer from outside. I've never seen from inside how this works. But we had important cases that basically were not executed anymore because Russia left the Council of Europe or was expelled. This depends on how we think it, but the Ukrainian versus Russia Grand Chamber decision regarding the Crimean situation was important, and also the second judgment by the Grand Chamber regarding Georgia versus Russia. But basically Russia was open to execute, but then when they left the Council of Europe, then it was obviously not executed anymore. And recently, in July of last year was decided the Ukraine and Netherlands versus Russia case that basically dealt with this flight that took off on Amsterdam in the direction of Kuala Lumpur and flying over east of Ukraine, and it was shut down. All people died on the board. Almost 300 people from 17 different countries. In the ruling on the merits, the court underlined the nature and scale of violence in Ukraine and the statements of Russia concerning Ukraine's right to exist and how this threatened the peace in Europe. And based on the evidence provided the parties, it concluded that the Russian Federation was responsible for widespread human rights violation against Ukrainian citizens, including execution, torture, notably rape as a weapon of war, arbitrary detention. So they dealt not only with the problem of the shot airplane, but also the other violations in Ukraine, and basically even now 10,000 individual applications are pending before the court because of violations connected to the conflict, to the war between Ukraine and Russia. But as we know, in 2022, Russia withdrew from the Council of Europe under Article 7, 15th of March, and on 16th of March, the Committee of Ministers decided to expel Russia with immediate effect. But now, however, as for the court, it was postponed by 6 months. So basically what happened, what Lavrov was asking for. So then I don't want to enter into the challenges to the rule of law, because I think this is the most well-known part of the court last year's activity. But let me mention that partly the court was dealing with, so to say, attacks against the judicial independence of the national courts, and this was basically, a lot of countries was involved in, from Iceland, but most of them regarded the Polish court system, to which you already referred. I don't want to go into details regarding them. Then the second kind of attacks, so to say, are against the European Court of Human Rights itself, and criticizing, for example, the court, to creation of positive obligations, opening up the way to costly economic and social rights. Secondly, the overextension of the living instrument doctrine, the very, so to say, very evolutive interpretation of the convention. 3, the use of interim measures, Rule 39, that a measure that is not in the convention, as I have mentioned. And also other criticism pinpoint a conceptual overreach of human rights, saying that the court is continuously inventing new human rights that are not included into the convention. However, the solution, but also the court answers to this is, and the Council of Europe answers, to underline the importance of subsidiarity, saying that the domestic jurisdictions are the first to deal with convention violations, and there is a large margin of appreciation for the national authorities, especially where there is no European consensus. And this was by Protocol 15 also embodied into the text or in the preamble of the convention. Now this is not just a method elaborated by the court itself. But regarding this, I think it's worth to mention a recent development. This is regarding the migration crisis. I have to say that when I arrived to the court in 2017, there was an euphoric ambience there regarding that those previous judgments that regarded mostly dissidents from East European countries or from Russia arriving to an airport in Western Europe, this was extended to the migration from the Mediterranean and from Asia and other parts of the world. And they were very, very proud of it. I have to say that when I was elected to the court and I finished my mission in Italy, where I was ambassador, and I had to say goodbye to the President of the Republic. He told me that he was invited and expected to go to the Council of Europe to deliver a speech between the Parliamentary Assembly, as other head of states do it regularly, but the government told him not to go because of a judgment regarding Italy, the so-called Califia judgment, when basically 3 Tunisian citizens were kept on the board of a ship for 3 or 4 nights, and Italy was with that violated the convention and was condemned. When I personally saw with my eyes how Italy was fighting with this incredible migration wave, basically left alone by all the other countries in Europe. And critically, I have to say that, for example, even East European countries that were not involved in this southern migration wave just realized the seriousness of the problem since when Russia allows to go to the Lithuanian, Polish, and other borders the migrants, and now is pending before the court these so-called pushback cases. But what was said that in last year's May, basically almost a year ago, 9 European nations, led by Denmark and Italy, Austria, Belgium, Czechia, Estonia, Latvia, Lithuania, and Poland, issued an open letter calling for a restrictive interpretation of the Convention regarding migration. They argued that the case law limits the state sovereignty on deporting criminal foreign nationals and managing border control. Of course, the letter reaffirmed the signatories' commitment to European values, rule-based international order, democracy, inviolable dignity of the individual. But then, of course, I'm quoting, as leaders, we also believe that there is a need to look at how the European Court of Human Rights has developed its interpretation of the European Convention on Human Rights. Whether the court in some cases has extended the scope of the convention too far compared with the original intentions behind the convention, thus shifting the balance between interests that should be protected. Basically, the challenge of the migration is turned the criticism of the interpretation methods of the court, of the living instrument, and the evolutive interpretation. And basically this letter highlights the growing tension between European human rights obligation and the national policies aimed at restricting immigration and increasing security. And the issue is still pending. Now, the Council of Europe prepared an answer, but basically seems so probably it will not have serious consequences. But anyway, it was an interesting intervention to the work also of the court. I picked finally another issue, the climate problem. there is no right in the convention to healthy environment or something like that, but the court, by evolutive interpretation, introduced a number of series of cases regarding environmental problems. Basically, I think all countries have cases. Of course, the best known is the Italian case with the steel factories in southern Italy. But I checked that basically all countries have problems with for traffic noise, etc., and a lot of other issues are addressed by this case law. But here I think the turning point was when the court accepted 3 applications to be dealt with in the Grand Chamber. One from the Portuguese students, the burning rules, etc., which, but they did not exhaust the national, the domestic court system, so it had to be inadmissible. Then there was a innovative mayor of a French city that told that that his city will emerge in the sea, but then he left, didn't wait for the court, he left the city and his position, so that was had to be also declared inadmissible. I was substitute in this case. What does it mean? That I'm sitting there listening to the discussions, but I cannot take the floor at all. It's a difficult position because, and so on. And so I was following this, and 33 countries were invited to the Grand Chamber hearing, and so on. And then it turned out that basically all the 3 applications are almost inadmissible after all that. So finally the 3rd application of this, how to say, aged ladies from Switzerland, Klimasenjorinnen, was accepted, and Switzerland was condemned, didn't take appropriate measures against climate change, and was also a violation of Article 6, the right of access to the court, and under Article 8, the substantial violation. Here the problem is, strangely enough, there was only one dissenting opinion by the British judge Tim Ake, who was also our guest last year at the Human Rights Days. And I fully shared his opinion. Also, I understood that sitting there as a judge, with all the pressures from the outside, for all the performance we made with 33 countries and so on, is much more difficult to decide than sitting there, bored, listening to the suffering of the judges who were in the composition. But nevertheless, so the problem was that with all for me and for the separate opinion, that with all the evolutive interpretation, etc., the unprecedented challenge is posed to humanity by the climate change. The court unnecessarily extended the notion of the victim status, then created a new right under Article 8 that does not exist, and how to say the qualified the life arising from the harmful effects and risk caused by the climate change, impose the primary duty on contracting parties to adopt and effectively apply in practice regulations, measures against the irreversible future effects of climate change, etc. So that really, of course, under Article 8, privacy, the court is continuously creating new rights. But to a certain extent, this is good because it makes effective the court, but I think here it really went too far. And finally, coming back to the systemic problems, the addressing of those problems by asking, how to say, or obliging the state to take effective legislative measures, not by accident that a lot of authors say that the European Court of Human Rights is not a court dealing exclusively with individual injuries suffered by the applicants, individual applicants, but is the European Constitutional Court addressing systemic problems, overviewing and overruling the legislation, and obliging the states to take necessary measures. I personally was against this approach. For years I tried to keep myself the original intent of the convention, but original intent is not an interpretatory method of the court that is completely excluded. But I have to say that now, after 8 or 7 years, looking at the pilot judgment procedure and so on, I have to admit that although the European Court of Human Rights is not a constitutional court, but shows several signs of a constitutional court role, the direction and extent of this development require regular analysis and should be part of the dialogue that is taking place between national and international court. And the court's jurisdiction, procedures, screening mechanism, the right to individual petition have all changed and are changing over time, and the normative impact of the body's decision must also be assessed in this historical dynamic. These nice words were written by me, and that my position for the present day. As regarding the challenges, I think it's no doubt that the European Court of Human Rights and the judicial machinery need reforms, continuous reforms. Council of Europe, to a certain extent, is continuously working on this. I think that among these challenges, not the migration is the only one, or not even the most warranting problem, but both the internal issues, so namely that our system is that 95% of the applications are inadmissible. That means that here is a more structural rethinking of the functioning of this court should be kept to, how to say, to keep up with this nice word that is the most effective international human rights court. Thank you for your attention.